So, good morning, everybody. Good morning, Mr. Rackwitz. So, for the opening and as a kind of wake-up call, I have a couple of questions to you. Please ask yourself, why are we here in this courtroom today? What is the first answer that comes to your mind if I ask you the following questions? Are we here in this historic courtroom 600 because of the Nazi perpetrators who were convicted and acquitted in the bench over there? Or are we here because of the victims and millions of victims who did not survive the Holocaust in the Nazi regime? Does the answer depend on our perspective, on our moral understanding, or on our legal tradition? At the Nuremberg trials, the victims did not have any role in the proceedings beyond being witnesses. The whole proceedings centered around the question of guilt of the accused. And 20 years ago, we all know that, the Rome Statute established a system for victims' participation and reparation at the International Criminal Court. Yesterday, we heard from the founding fathers only, so I can assure you that at least the Nuremberg Academy had more founding mothers than fathers. We heard from the founding fathers that this system was not only an innovation, but also viewed as one of the cornerstones of the Rome Statute. And indeed, to date, thousands of victims have participated in different trials at the ICC. More than 5,000 victims in the Bemba case, more than 4,000 victims in Ongwen. These figures could mean that we are talking about an absolute success story, yet we all know that reality is much more complicated. So this panel will deal with the system of victims' participation and reparation at the ICC. What are its benefits? What are its shortcomings? Which expectations are raised, and is the court able to meet them? It's often said that the ICC gives victims a voice. And I do think that we should not speak about victims only in legal terms or in the abstract, but are aware that behind the legal concept of victims are real human beings who have suffered unimaginable atrocities, who have hopes and expectations when they participate in the proceedings, and who have hopes and expectations to receive reparations. Before I open the floor to the panelists, allow me to give at least one victim a voice. It's victim 480. Victim 480 was abducted in 2003 while she was walking along a road with her father. She was intercepted, she was brought captive and beaten. Their property was stolen. Father and daughter were kept in a base where victim 480 was raped several times per day in front of her father. Later, she has been diagnosed with HIV. Victim 480 participated, you may have guessed it already, in the case the prosecutor against Mr. Bemba. On May 17, 2016, she was asked by the legal representative for victims how she felt after having expressed her views and concerns to the chamber. I feel good. I feel liberated. I feel relieved because I've been able to express what I've been feeling for years. And I think that having had the chance to let this out, I feel good, I feel better. Before she left the witness stand, she was asked by the presiding Judge Steiner whether she would like to address the bench. And yes, she did. She did address the bench with the following words. Today I'm nothing. I hope that the court will be able to ensure some form of reparations so that I can continue to live properly during that time that remains for me on earth. With these impressive words in mind, I would like to give the floor to the panelists. I would like to focus on victims' participation in the first round and on reparation in the second round. And I would like to invite all my panel members here to engage in a discussion and to comment on the contributions of the others, if they wish to do so. Philip, let me turn to you first. As Chief of Victims Participation Reparation Section at the ICC, what happens now to victim 480? Is it up to you to inform her that she won't receive any reparations?
Thanks a lot. First of all, a parenthesis, thanks so much to Klaus and to the Nuremberg Academy for the panel and for this extremely timely conference that we're having. I'm really enjoying it very thoroughly, and I hope that everybody is. Now coming back to the question, which I would have liked to digress a bit more, because the question is actually the most difficult one. For the simple reason that we're now looking at a situation in Bemba which hasn't been contemplated, or which has been contemplated, but rather in a rather simple way, and that is, if there is no conviction, the story ends in terms of reparations. So that's, if you want, what you would take out of the statute. Right now we're asking ourselves the question, and that is, we as in my section, the VPRS, but that is also all other actors in the field. That is the legal representative of victims, that is the trust fund. How do we tackle this particular situation where 5,229 participating victims, roughly 650 victim participants that are in the hands of the Office of Public Counsel for Victims, and obviously a good couple of thousands of victims that haven't even been able to come forward. What's happening? And the key challenge here is not so much only to inform, but also to know what content to convey. And to give you the short answer then, yes, we're looking very much into informing victims of what the situation is, what does it mean, what the chamber has ruled, and what does it mean, what the Rome Statute is going to bring you or not bring you. But that again leads to the other key question: what is the Rome Statute not, or what is the Rome Statute going to bring you? I think we're going to get to that a little later with Peter. So I'm pushing the difficult part over to the other side of the table. Exactly. But yeah, the current stage is indeed that we are actively engaging and preparing to reach out and inform in a much more comprehensive manner than we've done so far, in explaining to victims what the situation is and what the situation will be.
You started already to speak about the rights of the victims. Could you please elaborate more on the scope of the rights of victims, and what are the limitations, really?
So the rights of the victims, I would wish to say that we've only a very rudimentary system established by the statute itself. If you look at Article 68.3, that really gives pretty much full liberty to the court, and in particular the judges, to design how the victim participation can look like in a chamber-per-chamber approach, even if you want. And this is also how things started off. More guidance is given by the rules, in particular Rule 91. And if you want, the framework is also provided in that. We do have de facto a system where victims are represented by a common legal representative. We started off with a slightly different model in Lubanga in the early days, but I think if you look at the more recent procedures, you're looking at a plurality of victims being represented by a so-called common counsel. Judge Trentafilova made reference to it yesterday, in that being also a viable way how victims can be represented in trials. So that's the first thing. We have representation. These are legal professionals that are conveying the necessary legal submissions in court. But you also need to have the other end of the stick, and that is who is liaising with victims in the field. And that's a challenge that I want to come to later. The set of rules that we're looking at is one that is, I would think, now, today, rather inclusive. In particular, if you look at the very recent jurisprudence, and we have the presiding judge of one case amongst us who has actually brought this to a, I think, what would want to call a pretty balanced equilibrium. We have had in the Ongwen trial altogether 7 witnesses being called by the 2 victim teams. That is, I think, so far unprecedented. And nobody so far has said that this was to the detriment or prejudice of anybody, or that it slowed down the proceedings. And I think that's also another interesting point in order to add to what we had yesterday. The rights in particular, we're looking at the possibility, as I said, to call witnesses, to present own evidence, to ask questions to witnesses of the parties with the leave of the chamber, to make opening statements, closing statements, to make submissions in court in response to motions by the parties. I think we're looking at a system which is rather inclusive and which we have seen replicated also in the more recent hybrid solutions. So I think that there has also been a little bit of a pioneer function, if you want, of the ICC in terms of the rights that have, as they have been developed by the judges. And now we have more sophisticated legal ramifications in the newer courts. If you look at the Kosovo Specialist Chamber, I think we're looking at a more defined system in terms of the written law than we have it at the ICC, with an aggregate level of rights. So the scope of rights, I think, is pretty well defined. Limitations. The limitation is, I would not so much think one that is so palpable in the courtroom. The limitation is rather one that plays a role in the field. And that is, first of all, the limitation of what the court can do vis-à-vis the victims. We're looking at mass crimes, we're looking at mass victimization. That in turn means you have thousands, not hundreds, you have thousands of victims that have a right to participate as per what they suffered because of the huge complex of criminality. I again make reference to the Ongwen case. Look at the charges. You will see that these are not charges that only enable 4,500 victims to participate as the situation is now. No, we're looking at many more victims that simply haven't been able to submit their application in time in order to be participating. But the challenge here is, how does the court reach out to these victims? How does the court, in terms of quantity, bring all these victims to the attention of the chamber in terms of what they suffered and whether that suffering corresponds to the charges, which is the necessary hurdle for them to participate? So that's challenge number one. How do we have our people, enough people on the ground to actually engage with these victims, explain to them what does the court do, what is a court, to start with. For those of you that have been to Gulu or other places in northern Uganda, you will know that the concept of a court is maybe something that you will have to dwell on for half an hour in order for people to understand why you're there and what you want. Much worse so even in other areas where the court is active. That's challenge number one. Then comes number two. Even if you're able to take care of the quantity, how about the quality? How often do these victims actually have contact with their counsel who comes to see them or who communicates with them in the field and who actually engages with them in terms of what's happening in the courtroom? Again, an extremely capable courtroom lawyer on behalf of the victims is a great thing. We've seen a lot of very positive developments, how even the prosecutor's case could be, or the investigation could be sort of increased. I'm talking about Georgia. But again, what does that mean for the victim in the field if the victim doesn't even potentially know what is happening in the courtroom? So I think that's a big limitation. We need to be able to really connect the dots, that what's happening in the courtroom in The Hague is actually something that is supported by the big victim communities in the field and understood and pushed forward so that it's actually meaningful.
Thank you, Philip. Peter, also as a kind of follow-up question to you, to our quotation and victim 480. After the Bemba acquittal, the board of directors announced immediately, a couple of days later, that you will launch a program for the benefits of victims and their families in CAR. Could you please explain more of the background of that announcement and how you are going to prepare this assistance program in CAR?
Thank you, Michaela. Before answering the question, I'd like also to acknowledge the Nuremberg Academy for organizing these days. I think it's really important to have these kind of meetings with this high level of participation of key stakeholders over the past 20 years and longer in creating the Rome Statute system. And indeed, victims are an essential part of that by design, and now it's time to put design into practice, into the various dimensions that have been foreseen by the state's parties. I do appreciate what you said, Michaela, earlier, that there is a difference to be made between the legal concept of a victim and the human dimension of being a victim, which sometimes gets lost in proceedings for understandable reasons, because you need to conduct proceedings in a way that it is responsive to the legal framework. But victims participating, victims who may benefit from reparations, are not in the courtroom always. They are in their homes, they are in their communities, and they are in circumstances which are often very, very, very difficult. About the decision of the board of directors shortly after the acquittal decision in the Bemba case to step in with its assistance mandate, I may need to provide some background. The Trust Fund already in 2010 wanted to launch a program in the Central African Republic, an assistance program. And we were about to do so actually in 2013. We had the implementing partners, the whole procedure of selecting implementing partners, building a programmatic framework completed. Signatures were pending, and then there was a coup in the country, preventing us effectively to become operational for a long period of time. We have, as a fund, maintained the idea to become active in the Central African Republic since then. At the same time, and we weren't able to do it for a long time because of the security situation, but for us at the same time, when we felt that there might be a prospect of reparations proceedings, we thought that that would not be the best moment to launch an assistance program, because that might be confusing. It might also be asking more of the limited capacity and resources of the fund than we had available. So we decided to wait for the outcome of the Bemba proceedings, and at a certain point in time, we began to have a feeling that things might not go well, although we didn't expect the acquittal decision to come out in the form that it did. Having said that, so we were able to decide quite quickly that if no reparations proceedings would be, no further reparations proceedings and implementation would be a possibility, we would still have the assistance mandate to step in, and that's why the decision came to do that. I think it needs to be understood that this is not only for the Bemba victims, although they are going to be prioritized for obvious reasons, because they have been participating for a very long time, they have been suffering for an even longer time, and there's many of them who are in quite vulnerable conditions. However, the wider scope of the program will be the same as the original, which is to focus on victims of conflict-related sexual violence throughout the CAR 1 situation, eventually. So that will be the final scope, even if we are starting with the most vulnerable victims coming out of the Bemba proceedings. And some of them are indeed in really difficult circumstances. The victim that you quoted, I've met her in I believe it's the same person. I've met her in Bangui, a very, very brave person. She also said in the court, during the court proceedings, I want the world to know. That is why I am being a witness. I want the world to know what happened to me, what it means to a person to be treated in this way. She and a couple of other victims that we have been communicating with and been engaging with are suffering from HIV/AIDS for a long time in a very bad condition. We are providing support as a first step, and we are working very, very closely with the legal representatives, including the OPCV, to have the most vulnerable victims come forward first, so that they can have the benefit of a package of support, which is a reparative package, which includes medical support. HIV/AIDS victims do not only need retroviral medicines, which are being given for free in Central African Republic. They often suffer from the so-called opportunistic diseases, which they have to pay for themselves to be treated. They don't have that money, so anyway, they have a very difficult medical situation. They need psychological support. They need housing support. Why? Because they're being stigmatized in their families and in their communities. They don't have stability. They need nutritional support, because otherwise they won't support the medicines. They will need support in generating income. They will need support to have their children into school. If you ask these victims, what is the most important thing for you right now? They say, my children need to go to school. They need to have an education. They need to build a life. That is the first objective that I have. I may not be much longer in this world, but I would like to make sure that they have a life.
Thank you, Peter. Amanda, as a lawyer and practitioner, you're working as a legal director for the Canadian Centre for International Justice. What do you say from your professional experience when you support victims and survivors of atrocity crimes? How do you see and assess the victims' participation system at the ICC, especially also compared to your experience and work on the national level in Canada?
Thank you, and thank you for having me here. Indeed, I work with survivors and I work with victims, and so I think from the outset what I'd like to say is that victim participation is so essential. And I think that we're at a point now, especially as we look back on 20 years, that it's not so much a question of whether or not victims should participate and whether it's worth it. I know there was a rhetorical question yesterday, but I really think that we need to get beyond the question of victim participation and move towards how we can better involve and meaningfully engage with victims and with survivors. And so, coming from a common law system in Canada and recognizing that the ICC does have a much more adversarial tendency, the victim participation provisions are actually quite progressive for someone like me working with survivors in a criminal justice process nationally that doesn't actually provide as much opportunity to engage in and to meaningfully participate. And so this is an opportunity. But I think that what I'd like to focus on today, given that there are actually no victims here, is to focus on what I've heard from my clients and from the survivors that I work with and endeavor to represent a little bit their perspective here on the panel. And so I can't emphasize enough the fact that we would not have international criminal law and we would not have international justice without victims and survivors. It wouldn't happen. The reason that some of these crimes are so egregious is because of the impact that they've had on our society, and that is the impact that they have on human beings and on people. And we've had that recognized here on the panel too. And so I think it's really crucial that we don't lose the plot as we look at process and procedure and technical issues, and that we really need to take a step back and remember that it's not simply about retributive justice, but it's also about restorative justice for the victims that have suffered harm. And I think that we need to have a victim-centered approach in every aspect of how we engage with the International Criminal Court, even in the most tedious of legal arguments. So I'd like to spend my brief time to discuss one major issue that I've identified through work with survivors and one major opportunity when it comes to victims' participation. The main issue that I see is that we have a tendency to instrumentalize victims in these processes, and that's not okay. And I think that if we expect victims to supply our work so that we can carry out the legal work, that we need to expect to give back to the victims in ways that are meaningful to them. So this applies to participation. It also applies to reparations, which we will get to later. And so I'd like to focus on the rhetoric of international justice and the process of international justice. With the rhetoric of international justice, we can see that it is saturated with references to victims. Even just yesterday, when we discuss why we do the work that we do and why it's important, we constantly see references to the importance of justice for victims, to the need for courage and the ultimate courage of the victims, and the need to restore human dignity. And so we cannot be genuine in our concerns for these issues without meaningfully engaging with these victims throughout the processes. Otherwise, we're instrumentalizing them because we're using their name and we're using the notion of who they are and what they represent to justify the work that we do. And so if we will do that, and I think that there is a valid reason why the rhetoric is so important, then we need to also follow up with actually meaningfully engaging with these people that represent justice to us. And secondly, the process of international criminal justice already expects and already relies on victim participation. There is no thorough investigation or a thorough prosecution without the information and the evidence and the testimony of victims and witnesses. So regardless of whether or how we envision this participatory regime, we have to acknowledge that we already do rely and we already do need victims to participate so that we have the evidence necessary to be able to prosecute. And so if that's the case, our engagement with victims cannot be unidirectional. We can't simply extract information from victims for the sole purposes of legal arguments and the things that we think we need for the prosecution. We need to see them more as just a fountain of information. And so I think it's really important that we constantly remind ourselves that indeed victims and survivors are not a fountain of information. These are human beings. And so while they have important information and important evidence that we can use legally, the rest of what they have to say is equally important, and we need to contextualize all of it, and we need to listen to all of it. These are individuals whose lives are irreparably harmed. And these individuals are often in a continual process of trying to overcome the extreme trauma that they've suffered. And so there is a constant re-traumatization of survivors and of victims every time they share information and every time they share their story. And so if we're going to engage with them and we're going to recognize that this is a part of the process, then it needs to be bi-directional, and we need to make sure that we're also offering them the platforms that they need and the space that they need, and carving out opportunities for them to engage in ways that fulfill the needs that they have. And so this gets me to the one great opportunity that we have with victims' participation and a way of avoiding instrumentalizing victims. And so we can't think of victims as an afterthought in this process, and we can't see them and their participation as secondary or as tangential or even as a burden to a system. I know we discussed yesterday on, how to balance the rights of the accused and the length of proceedings, and I don't think that we can look at victim participation as a burden in that process. I think it's essential to that process, and so we have to think of how we put the victims at the center of what we're doing. And so we do need to develop a culture in international criminal law that incorporates the needs of victims, and we need to discuss victim participation as more than just a means to an end. It's more than just trying to get information, but it is itself a form of justice. And that's what I hear the most from my clients and from the people that I work with. Victim participation has a lot to do with having those individuals that are most affected by these crimes have a say and to share an independent voice on who they are and how they've been affected and what has happened to their communities. And so if we allow victims to participate meaningfully in specific cases, it's a way of recognizing their suffering. And it provides a form of emotional and psychological satisfaction, which is very important. And I do think that being heard and recognized as a victim is, on an individual basis, is a first step to a larger sense of reconciliation within a community. So I think it's really important to look at victims' participation from that holistic perspective. So I'll leave it there, but I'm happy to engage again more.
So since you've mentioned it a couple of times, allow me this more provocative question. Do you see the danger that victims are instrumentalized at the ICC? Absolutely, absolutely, and I think that
I've noticed this very much on the national level, and I do see certain patterns repeated on the international level. But some examples that I can provide is that when we think about victim participation, we also have to look at the process of how investigations are conducted and how information is gathered for prosecution. And oftentimes, for example, you'll have national jurisdictions that are interested in a perpetrator in some way or interested in a situation in some way, and not just one national jurisdiction, but you get investigators from Canada, for example, or from France or from Switzerland or other areas that are engaged in universal jurisdiction, for example, coming into these contexts and engaging with survivors. And they each have their own agenda, they each have their own theory of a case, they each have a specific perpetrator, a specific interest, and they come in and they're simply extracting what they can and cherry picking to fit what they need to do. And so sometimes we will have had clients or survivors that have sat there, and in 1 week they've been met with 4 or 5 different people doing 4 or 5 different processes and not engaging with each other in one bit in that way. And so they're constantly answering the same questions, constantly engaging on really difficult topics, and constantly giving information that has been asked, but never fully being able to share what they want to share. And so I think when we think about the instrumentalization of survivors, it's not just in the courtroom and in the hearing, but it's the whole process of how we put together an investigation, how we put together a case, and the need for cooperation from the other side amongst the international mechanisms and the national and the domestic national prosecuting authorities, and making sure that there's a much more holistic and a big picture approach to what justice is and how we engage with it.
Thank you very much, Amanda. Fiona, now it's your turn. I mean, you're currently working as the senior managing legal officer, legal officer is it, sorry, at Open Society Justice Initiative, but you've been one of the founding mothers, right? Of the Rome Statute. Well, I have a founding mother, sorry. We've heard from Philip how the current victims' participation works right now. Looking back, and from your perspective, from your Rome perspective, at what was the original way victim participation in the proceeding was envisaged in Rome, how has it played out since then? And do you think that the right balance between the of the interests of the victims on the one side and the rights of the accused of the other side is met?
Thank you, and I would like to start by expressing my appreciation to the Nuremberg Academy for inviting us all here. I think it's really excellent to have this opportunity to step back after 20 years, and indeed as one of the, I could say, sort of one of the sausage makers of at least of the victims' elements in the Rome Statute. I feel that that's very useful. And of course, at the time, you put something on paper, and it's quite a different thing when you come to put it into practice. And so I should also say that I was, for those of you that don't know, that I was Philip's predecessor, the victims' participation and reparations section in the registry, so charged with trying to put this thing on paper into practice. And I should say, when I was at the court, I think my mantra was, victim participation is manageable. It's just a case of arriving at efficient ways of organizing it, an application, an admission system, legal representation, and the actual participation in proceedings. It's difficult, it's a whole new area of practice, but it's possible. And I think I really appreciated the discussion in yesterday's session at the end of the day, and so I don't think I need to go over that ground again. I would say broadly in terms of organizing, streamlining the ICC system for participation of victims in proceedings. We're basically there. Now, I think in terms of reparations, we're not, and we'll come to that afterwards. I think that the victim's role in the proceedings has more or less panned out as envisaged in the Rome Statute. I think some feel that it's more limited than it could be, particularly in the early stages, that victims have too little say at the crucial early stage when the size and shape of an investigation or a case is being determined. And I would like to see some shifts there. On the other hand, I think that victims' lawyers do have significant opportunities, particularly during the trial and reparations proceedings, to put forward the views and concerns of their clients, and that this has been normalized as part of the ICC practice. And I think that, the contributions, and Judge Trentafilova raised this yesterday, of herself and other judges that were really seeking solutions together with working together with the registry really was very important. Now, the question of whether the right balance has been struck, whether the participation of victims has actually infringed on defence rights. And again, we've covered that ground to some extent yesterday, because I think the first question to ask is, what would it look like for the victim's role to overreach in the proceedings, to make the trial a trial unfair? Of course, unduly lengthening the proceedings could be one, and we I think dismissed that one yesterday. Perhaps inappropriately bringing evidence into the proceedings in ways that would violate the rules of evidence. But then the defence has the opportunity, as we've seen during trials, to raise any concerns about specific interventions of victims. And interestingly, we haven't seen defence in cases arguing that per se the participation of victims in proceedings has made them unfair. And I think that what's been crucial in this regard is the role of the trial judges and they've really demonstrated that victim participation can be managed in a way that doesn't infringe on fair trial rights. And it's really their job to make sure that that doesn't happen. And I think they've been very vigilant in that. I think it's very interesting to note that the very first, the presiding judge of the first trial, Judge Adrian Fulford, in reflecting on his experience, said that he was convinced, he's a common law lawyer, hadn't experienced victim participation in his national system, and said that the experience at the ICC had really convinced him that victim participation could be accommodated effectively in ICC trials. Now, I know that dealing with this case by case means that some victims' representatives complain that there isn't really much certainty about how, there isn't enough certainty about what they're going to be allowed to do, and sometimes it can vary from chamber to chamber or context to context. And I think in a way that's inevitable, and that if we're going to expect the judges to play this role properly of controlling the proceedings so as to keep them fair and not allow the victim's role to overreach, then there has to be an element of, if you like, uncertainty.
Since you're now working again for an international non-governmental organization, I wanted to ask you a question about the role of the civil society and how the court uses the impact of the civil society. Is there room for improvement? And how would you assess the role of the civil society in the proceedings and in victims' participation?
3 points, if I may. First of all, there's no choice in the matter. The court has to rely on civil society to access victims, to enable them to play a meaningful role. Simply wouldn't be able to do so without them. And I'm not only talking about actually making victim participation and reparation meaningful, but also the public information and outreach that are so crucial for the court's impact. And again, we touched on this yesterday. I don't have to go over that. I think, one question is, what do we mean when we say civil society? And I think it's important to bear in mind that, if you really want to reach victims and affected communities and have this two-way, especially to have this two-way relationship that Amanda touched on, then you really have to go to the local level to find interlocutors, and there may not be NGOs, there may be individuals or community representatives or perhaps just service providers on the ground. There may not be formal NGOs. in order to find interlocutors who really are close to the communities and have their trust. The question, you raise, can civil society be really considered representatives of their communities? And I would say that, of course, mostly, but not always. And the court does have to work out, who's reliable and who isn't. But I think this is distinct from the question of, if you like, political bias. I don't think it's realistic for us to expect that local groups on the ground are going to be separate from the political environment and somehow apolitical. I know sometimes you hear that people expect that, and it's simply not realistic. But I think what's really important is to work out who is acting on good faith on the part of the victims and who isn't, and that's the key question. Second point, it shouldn't only, of course, be about what civil society can do for the court, just like it shouldn't just be about what victims can do for the court, as Amanda said. The flip side of that, of the fact that the court doesn't have a choice but to work with civil society, is that really the court needs to take on board the responsibility that carries. Yes, security is one aspect, and where there are security concerns, we find that the court itself is quite quick to say that it can't go and engage directly with the local communities. And civil society, of course, are free agents, and they may decide that they will do so. And take on this task of engaging with victims about the court. But of course that can expose them to risk. But I think it's important to bear in mind it's not only security that civil society are risking, but also their own reputation and position in the communities. Imagine, on day one, like a civil society representative goes to the community, talks about the ICC, maybe says that they're there to help to engage and help victims to participate in the proceedings. And then, a few months later, perhaps even years, that same civil society representative has to go back to the community, has to explain that the ICC maybe isn't going to open an investigation, or that there won't be reparation, or certain victims won't get reparations. These messages will then be associated with that civil society representative in the community's minds, and it can affect their standing in the community and their ability to do the other important work that they're doing. So I think that it's simply not fair for the court to not grapple with these questions. To say there are some really good examples, I think, I've seen of where the registry has taken these responsibilities seriously and worked in partnership with civil society, but it hasn't always been as open as it could be to this. For example, in listening to what civil society say about how the court could, for example, communicate with communities in its own name, even without being present in the country. Third and final point. I wanted to come back to the quote that you gave initially, Michaela, and the expectation that the victims have about the court. And I think we have to understand, if you like, accept that the court can really never do enough when it comes to outreach and engagement with victims. I'm mindful of a study that was done, some of you may have seen this, by the University of Berkeley, California in 2015, where they interviewed more than 600 victims, asked them about their experience in interacting with the court. And they did their research in the very places where the court and the registry in particular had done the most to reach out to victims and affected communities. But still, the finding overwhelmingly was that victims felt they didn't have enough knowledge and support. And another very important finding, I think, of the Berkeley study was that the victims' satisfaction with the ICC depended largely on their personal interaction with ICC staff and with their legal representatives. So, of course, while accepting that the court can never do enough, and that at least in the short term the court won't be able to have significantly more resources to do this work, it's really a question of being smart in targeting the resources that the court has, working effectively with civil society. And some very important lessons. The registry in particular really needs to start working on the ground earlier, and at the very least during the preliminary examination stage, has to make sure that its staff and the legal representatives have the skills and resources to work effectively in the field and with victims, and has to understand the world that civil society is operating in, accommodate that as far as possible, adapt their communications to take into account these complexities, not just go out and repeat the standard messages. And don't overpromise. I think Amanda mentioned this, really important. Explain things as they are. You know, don't go into the field saying, you know, the court's here to end impunity. Don't overblow the role of victims either.
Thank you. Philip, as Fiona has said, would you say that the resources are the biggest challenge in the next years for the court in order to deal with victims' participation and the high figures? Or are there other challenges?
Your Honors, this was a leading question. I would think, yes. Resources are a problem in that they are at the heart of what Fiona very rightly put, is the amount of contact, direct contact, that victims will have with whoever from the court on behalf of the court is interacting with them. If that is their legal representative, well, in most cases, as we know, victims will be indigent. That means they don't have funds to entertain their own legal counsel to represent them in the trial. That means, in other words, it will be afforded by the court's funds, and these funds are then limited, which brought us to common legal representation in the more recent trials. So obviously, here's a financial goalpost, if you want. The other challenge that also is finally related to finance is how much can, for instance, the registry do? And that is, how many operators or how many staff do we have on the ground that can directly interact with victims, with victim groups, with NGO society, in order to have a constant flow of information and a constant engagement. And I think this is indeed, if you want, one key challenge. I would, however, also say that with all the challenges, what is another challenge is how inventive are we in terms of making the system work. And I give you an example. We heard it just now from Amanda that victims may not be able to tell the whole story, which may be linked to the fact that the charges are limited to whatever the prosecutor wants to try in that particular case in a bigger situation. Now, inventive or clever charging actually gives us as the registry on the victim's end a pretty good leeway. And I give you an example of the Al-Hassan case where the prosecutor charged persecution. Now, persecution can be perpetrated through a number of different acts. Now, even if these acts are not explicitly spelled out in the charges, whatever a victim tells me has happened to it, if it is only part of the persecutory framework, I can hear that victim's story, I can bring that victim's story into the courtroom so that the victim with its story can be participating. And I think that is just a clever way how to make the system work where you're not necessarily immediately talking about resources. Another, I think, important factor is, again, also something that Fiona already said. How do we interact with all the actors that are on the ground where we get cost-free synergy effects? And that is, for instance, civil society. That is, how good does the court interact with civil society? And that's not just how good does the victim participation and reparations section interact in terms of identifying relevant victim groups and having a good picture of a mapping in terms of where are victims and how can we reach out to them. It is also a question of how well does, for instance, the public information and outreach component of the court respond to the challenges as they are being identified by civil society on the ground. So I think, again, it's a question of intelligent usage of all actors that are in the field and of synergy effects where we can. So this goes a little bit beyond, I would say, the rather simple argument of, yeah, we're constrained by resources, therefore we can't do everything. Yet, again, I also have to take this as a key factor. The expectation management is one that is always a factor that has to be maintained as a key challenge. We're not the sort of regular interactive forum with regard to victims. We all understand what the limitations of the entire system are. But those that are directly affected by the crimes see and consider the court as something that will bring help. And they all have their own concept of what that is. And we, as the actors that come into the field, we don't necessarily know what they think we're bringing. And this is one big challenge, to actually understand how to react to what victims see us as bringing or doing. And it's partly for the court, but to a very large extent also for the trust fund for victims, because people will have many different concepts.
Thank you, Philip, also for already handing over to Peter. The reparation mandate is directly connected to the judicial process and its outcome. And of course, we discussed very briefly BEMBA, but from your perspective, from the trust fund's perspective, what would you say are your biggest challenges in terms of the legal, political, and again, financial connections to the reparation proceedings and its outcomes?
Thank you, Michaela. That's not a leading question, that's a loaded question, but I'll be happy to answer that. Allow me to bring into play another element, but before doing that, saying that it's not only about challenges, perhaps, that we should be talking, but also about opportunities. The Rome Statute has been built 20 years ago, it's operational. The final chapter of the Rome Statute to become reality now, only now, in these past years, is the reparations mandate of the court and of the fund, and the reparative justice paradigm. A lot of work still needs to be done to have a complete picture of how things might look like, how things might be translated from the paper of the Rome Statute itself and of the regulatory framework into what my chair of the board often quotes, says to be the legally viable and operationally, legally sound and operationally viable implementation of reparations orders. There's one element that you did not mention, and that is what I've been trying to talk about, and that's the systemic element, because reparations are not only the concern of the fund, they're the concern of the court, but they're also the concern of the states. And I feel it's really important to highlight the responsibility of the states as well, to make sure that reparative justice becomes a reality for victims. And I'm not talking about funding only. Of course, I'm talking about funding, but I'm also talking about the political and moral support that needs to come from states who have built this system to ensure that victims who are eligible to benefit from reparations are able to do so in the best possible way. And I think that goes to the systemic dimension of the Rome Statute, and one part of that is still being constructed. Legal challenges, we have some judges in the room here who in the past and currently have been constructing the reparations practice of the court. I'm seeing Judge Trendafilova and Judge Schmidt. It's been, there have been some hiccups in the procedure with some basic questions that still needed to be answered. What is a reparations order? Quite some debate about that in the Lubanga case. What is liability? What is liability? Who is liable? Who can the chamber order to pay for reparations? It's the convicted person, has been confirmed by the appeals chamber, But that is very important. It's not only important from a financial perspective, it's also important from a legal perspective. It marries the criminal responsibility of the convicted person with the financial responsibility for the harm caused by the crimes for which he or she has been convicted. That's a very important and central element of the Rome Statute's reparative justice paradigm. Legal challenges, there are procedural challenges. How to ensure the process is efficient and effective. And we are finding our way. I think we are indeed finding our way. Different trial chambers looking at similar problems to solve in very, very different cases and very different situations. I think it's too early to say how exactly the reparations practice of the court may look like, because there will be different cases again in other countries with different harm paradigms that needs to be addressed in the context of reparations proceedings. There's a lot more to say about that, and maybe we can have some discussion about that in the final part of this panel session. Financial, I talked about liability. At present, all the convicted persons are indigent, which means that the fund has a role to play. It is not. It's at the discretion of the fund, of the board of directors, to decide to what extent it can complement the payment of reparations, with the understanding that liability remains with the convicted person, and that should that person win the lottery or write a book or have proceeds from a film, that money can be retrieved by the court and then handed back over to the fund. But not to let victims wait for reparations, and to allow at least the majority of the reparations order to become a reality for the victims. The fund has the opportunity to co-finance reparations using the resources, not using the budget of the court, using the resources it is finding from voluntary contributions and donations. That brings me to another systemic challenge to the Rome Statute and to the fund in particular. The court is funded through assessed contributions. The fund is funded through voluntary contributions, donations. That is a much more uncertain funding base. And if you look at the amount of liability coming into play right now in reparations proceedings, $10 million in the Lubanga case, $1 million in the euros in the Katanga case, 2.7 million euros in the Al-Mahdi case. These are volumes of money that the fund does not have readily available. We need to do more fundraising to go there. We are doing that. We're actually having success in raising funds, but it is a systemic challenge that cannot be met alone by the practice of voluntary contributions, because that is a practice which is under pressure with many states, from which many international organizations are suffering already. We are managing to have bridges built within countries to official development assistance budget streams, which are typically larger and have a longer perspective, allowing us to have long-term funding arrangements with certain donors, which gives us predictability of our revenue and some means to actually plan our financial engagement, both under the assistance mandate and also under the reparations mandate. But that's still not enough. Private donors, we are engaging in this market, a very competitive market, and typically for international organizations, not that funding stream that is going to give you the majority of your revenue needs. There is a need for a systemic response. There is a need for the fund to explore innovative ways of raising money for the cause of victims, and that is what the fund is doing at this moment. Then again, coming back to the States, we may come back to the States ourselves saying that there is a systemic financial response needed to sustain the implementation of the reparative justice paradigm of the Rome Statute, because otherwise there is a risk that even a successful prosecution will be tainted by the fact that the implementation of reparations can only be imperfect. And that is not a result that anybody would like. One option would be to do away with the reparative justice paradigm. I don't think many will agree with that. If you want to make this part of the Rome Statute work, it is time really to make sure that not only legally, not only institutionally, but also financially, systemically, the reparative justice paradigm of the Rome Statute becomes a mature and sustainable proposition for victims.
Thank you, Peter. Fiona, what do you think from your perspective? How has the court dealt with the reparations so far, and which role would you say should the trust fund play in the system?
Briefly.
Yeah, briefly.
It's so challenging to find the right way to deal with reparations in the context of criminal trials and where there are large numbers of victims. You know, all the international practice on how to do reparation in cases of mass violations has really been in the context of state responsibility. But a criminal trial is different. You know, you're not trying to deliver a comprehensive reparations scheme for a particular set of crimes. You're really trying to work out what you can pin on one individual who has been found guilty of specific crimes. And that is just the fact that we can't get away from. I have to say, I respectfully disagree with Maître Keita's suggestion yesterday. I don't share his view that the ICC should order reparations if it doesn't convict someone. You might be surprised to hear me say that. For me, the business of the ICC is to try the individuals who come before it. It doesn't have the power to order states, for example, to award reparations or to deal with reparations. Of course, the role of the trust fund with its assistance mandate is another thing, as is the possibility for having actually discussions with the relevant government. I mentioned that we still have a way to go on finding a way to deal with, a model for dealing with reparations at the court. I see some elements in the recent decisions in Al-Mahdi and Lubanga that I think are promising. In my view, it's not sustainable to have a system whereby judges are deciding on individual claims for reparations. There has to be a way found to avoid that, and to have the trial chambers, of course, set the parameters, and probably for the trust fund to have screening mechanisms, etc. And I think that it's a question of arriving at the right model that fully respects the fact that this is a criminal trial and the rights of the defense, but I think it can be done. Finally, what would I like to see looking ahead in terms of the trust fund? First of all, I think to engage earlier in new situations that the court faces. I think you're starting to do that, Peter. But not with the primary purpose of kind of identifying what the needs of the victims are, because after all, you don't want it to seem as if, you know, the trust fund's coming along as just another humanitarian agency, but rather to really explore the landscape in terms of reparations and to come in talking about reparation. I do see great potential for the trust fund to act as this kind of link and catalyst to help to bring about wider strategies for dealing with reparations in a particular context. You know, sometimes this might mean the court itself handling a case to sort of show as a model how it could be done, to show the way, if you like. But it also could be of really trying to help to lay out what a wider scheme would look like. And I also think that the trust fund can also help to advocate on behalf of victims in a particular situation. You know, depending on whatever their main concerns are on reparations, you know, to perhaps to help them to articulate that and to put that forward and get that on the national agenda in their particular country.
Can I just say something in response?
Please.
Yeah, well, if you ask me, I'll say something about the fund. I mean, I think it's really interesting what you say. We are indeed trying to intervene earlier under the assistance mandate. Something I wanted to say before, but you give me the opportunity to say it now, is that the assistance mandate is a reparative mandate. If you look at how it's been construed, it's a direct copy from parts of the UN Basic Principles on reparations, and it's been construed as such. So if the fund goes on and engages with victim communities, it's not asking, it's not doing a needs assessment, it's doing a harm-based assessment, and on the basis of that, looks at needs. The other thing that I think needs to be understood is that while reparations eventually be the end game of judicial proceedings, it will only, in most cases, reach a limited group of the victims who are in a particular situation as a result of choices made by the Office of the Prosecutor. I don't think that the Office of the Prosecutor necessarily, when making its charging, developing its charging strategy, looks beyond its own end game of getting a conviction and how a conviction may result in reparations and how reparations will be perceived in communities. If the charges are too narrow, you create additional risks for implementation of reparations that may be avoided. And in this case, I can refer to the Lubanga case. And I do think that OTP is more mindful these days. It will take some time for that to play out in reparations proceedings, but that's a very important point, I think, that needs to be understood system-wide again, not only by the trust fund. But the assistance mandate does have a reparative impact beyond the boundaries of proceedings, and I think in and by itself, that is a very valuable proposition coming out from the Rome Statute system, even if you may not be benefiting from reparations in a particular procedure, you may be benefiting from reparative measures through the assistance mandate of the trust fund that otherwise would leave you felt behind in the cold. And that is, I think, a very valuable dimension of the assistance mandate that shouldn't necessarily be made functional to the prospect of reparations.
Last question from my side to you, Amanda. As a victim's lawyer, which wishes do victims have in terms of reparations? Yeah. Please be brief.
Yeah, I will be very brief. I actually do very much agree with a lot of what was said on the panel about reparations. So I'll focus on two things. And one is, I think, the biggest issue that I see, excuse me, with my clients or with victims and survivors that I've worked with is that the length of proceedings is just as much an issue to victims and survivors as it is to a lot of the other actors that we've discussed yesterday. And so understanding that time is of the essence is the biggest request that I get. And I think that if we link this back to the idea of not wanting to instrumentalize victims and having this bi-directional engagement, then we need to, again, acknowledge that if we're going to rely on victims and survivors for the investigation and for information collection and evidence collection, that we need to also offer some sort of support throughout that process. And so the biggest thing that I would say here is that there needs to be a distinction, and we've had it made on this panel, but a distinction between reparations that are linked specifically to a case and to a conviction on a case, and the ability to engage with the assistance mandate of the trust fund in other creative ways that maybe even resemble my experience with the Canadian system, for example, which is a restitution compensation program that they have so that victims of serious crimes, regardless of a conviction or not, are able to get some form of compensation. And so looking at the victims that are already engaged in the ICC process and how we can provide a form of assistance that comes in much earlier in the process and that supports those that are engaging in that process.
Thank you, Amanda. Now it's up to you. Do you have any questions to our panel members? Please raise your hands. Let us start with the host.
I'm requested to stand up, and I'm happy to do that. But people can see me already when I'm seated, so no worries. Thanks to the panel first and foremost, and to Michaela for chairing it. On Friday 13 in July, the Pre-Trial Chamber 1 issued a quite remarkable decision. And that is a decision that is geared to Palestine. And they give orders to the registry at a point in time where the prosecutor is far from knowing whether she would ever open the situation. However, the chamber felt compelled to rule about that. That's not my point here. If I were the prosecutor, I would be delighted of such an interference. But anyway, no. But paragraph 10 is a very remarkable statement. In this regard, it's worth recalling that victims also have the right to provide information to, receive information from, and communicate with the court, regardless and independently from judicial proceedings, including during preliminary examinations. That means the chamber thinks that victims' communication should take place without any judicial proceedings. It can't be earlier, Fiona. So you just complained that it might not be. Would that decision change the world? Will victims from all over the world, regardless whether the court is investigating or not, having now starting to communicate? It is the registry now hiring hundreds of people in order to handle all these communications. What do you think about that decision?
Continue on that side, makes it easier with Rainer Huhle from the Nuremberg Human Rights Center and also member on the UN Committee on Enforced Disappearance.
Thank you, first of all, very, very much to this very rich panel and very reflective panel. I enjoyed it very much. And in fact, whenever I took note of an issue I wanted to ask you, the next one of you just touched upon that same issue, so there's not much left to ask in detail for me. But I would like, coming from the world of human rights tribunals or treaty bodies, with that difference that we deal with states directly and never with individual perpetrators, and therefore have always a view on overall public policies that we recommend to states how to change their policies in favor of victims and victims' rights. So the thing that really troubles me when listening to you is, where is the link between the individual and the collective, the community? I mean, you touched, various of you touched upon the topic, and I appreciate that very much, but still it is a challenge. And there's some issues I noted that I just want to ask you whether these would be entrances to deal with more collective victims, reparation and recognition issues. And that is, first of all, I mean, as a criminal court, you prosecute individuals, but you also, the ICC, I'm addressing you as if you were all of the ICC. The ICC is also investigating situations. That is his mandate. So I wonder whether one could not get more out of this idea, brilliant idea, I think, of investigating situations and therefore come to recommendations or decisions that imply more actors in that situation. I know you have not a mandate to direct any member state for any policies, but maybe there could be some more reflection on that. And the same question is, how far does the assistance mandate really go? Could it involve more actors as duty bearers in the process of reparation? So at the end, I think it is really about repairing communities. It's also from an individual victim's point of view, because we all know that a part of the suffering of victims is the danger of re-victimization or continuous victimization, that victims often cannot integrate into their own communities because of having been victims, because victims is not only a motive of compassion, it's also very often a motive of exclusion. So there is a link between the individual victim and the victimized community. So these are basically my reflection and question to you, whether you find any more concrete solutions to tackle this necessary link, I think, between individual and community victims. Thank you.
Thank you. Mr. Keita and Mr. Dicker.
Thank you. Thank you, panel.
Please keep your questions short.
Yes, I will be short. I will not polemic with Fiona, my friend, but I try to be pragmatic and realistic with victims, and I don't wish for victims that they take the risk to be disappointed and to be victim a second time. Vocabulary said a lot about the spirit, and I was shocked when I joined the court to have the expression hearing a confirmation of charges. And for me it was violating the presumption of innocence. It should be examining the charges. But the same for victims. I don't understand why the fathers or the mothers have chosen to call legal representative for victim instead of counsel for victim. Why? Why legal representative for victim? I don't think that is respectful for victim. And when we created the bar, the ICCBA, we have we put counsel for victim and counsel for defense. I think that is respectful. My question is why in ICC, because they are indigent, the victim do not enjoy the free choice of their counsel?
Patrick, if you introduce yourself briefly.
Sure. Just two comments from the perspective of UJ, Universal Jurisdiction Victims Representative Legal Counsel or Counsel for Victims, or speaking of vocabulary, survivors, which is a word we prefer because it gives more agency to the people affected. There are, of course, many problems and issues that have been raised here that we are fortunate enough to not have to deal with, especially in the situation that I mainly work on, which is on Syria, where we have very close contact to over more than 50 affected persons that are living in Germany. But it just made clear to me that many of the problems and issues that have been raised here actually are part of are just symptoms, part of a more structural problem maybe of the ICC and how it works in general, and I just wanted to make that clear because it hasn't been clear enough. Some of these might not be actually express themselves in other situations. For example, if the Abu Ghraib preliminary investigation would go forward, many of the problems would be different, but not the ones we're speaking about. I guess in Colombia it would be the same thing. Others are really going to the very core of the understanding of what the court is about. When we cannot make it clear to an affected person what a court is and what the court can do, then how can the society in general understand that? And I think this is really showing that the question of victims' participation really goes to the very core of the question of legitimacy of the court in the first place, and we shouldn't separate the one from the other and only speak about these problems when we speak about, oh yeah, victim representation or victim participation is so complicated. Second, also from our experience, not everyone at all really that has been affected by these crimes needs to be going into court, giving a statement, having the stage maybe even. We have had very good experiences in the recent past to bring in psychosocial support scheme in the very early stages, because many people that address us and say we want to play a role in the legal proceedings, whenever they speak to psychologists and not lawyers, it becomes clear that actually they're looking for something else. And also, Philip has mentioned the different perceptions of justice, and I completely concur with that as well. Many people also don't need the whole process to go through. Many of those who have testified with Christian Richer's unit here in Germany already had a strong sense of having been able to participate in something. Many of those expressed also that the arrest warrant that has recently been passed out against a very high level perpetrator, not against a mid or low level perpetrator, also shows them already that there is at least a way for justice to be made, and that also can kind of alleviate some of the problems that people have with regards to the length of the proceedings. I'm sorry, Richard, I just wanted to make sure to be able to say that.
Well, if I may, Madam Chair, with all respect to you, I owed Patrick a kindness, so I defer to his statement. So I want to remain in your good graces with my question. Given how central meaningful victim participation is to the courts fulfilling its mandate, given the results of the University of California, Berkeley study that I believe Amanda cited in terms of victim satisfaction, in terms of court interaction, rested in part on their engagement with their legal representatives, as well as representatives of the VPRS. I wanted to ask Fiona, Amanda, and Philip in particular for comments on the trend we documented in our research in northern Uganda in the Ongwen case of the pretrial chamber tendency to limit or preclude genuine victim choice in selection of their own legal representatives when indeed they were indigent. That was something that was deeply concerning to us, and we'd like to hear views on that. Thank you.
Philip, would you like to respond directly to Klaus Rockwitz and his question on Palestine and the communication?
You know this moment when you have these shivers and the neck hair standing up? Yeah, thanks for this question, Klaus. It's really nice to be back here. I will try not to lose my job in responding to this question. Paragraph 10 is indeed very interesting. We are dealing with a pretrial chamber that has taken a very inclusive approach as to the potential victim participation at the earliest stages. I think it is safe to say that this decision is a first at that point in time, and therefore a very interesting new advance, which stands there for its own merits. For paragraph 10 in particular, I may direct your attention to footnote 17, which is exactly after the sentence that Klaus mentioned, which is, there may be rights of victims already during the preliminary examination stage. Footnote 17 outlines something that is not a novelty, that we all know. Victims, when the prosecutor asks the pretrial chamber to start a proprio motu investigations, have a right to make representations. At that stage, we are in preliminary examination. An example being Georgia, another example being most recently Afghanistan. So that is something that is very legitimate and normal that it is being referenced. The same goes for the question of Article 19, jurisdictional challenge or admissibility challenge. These challenges can arguably be brought at a time where we're not yet in an investigation phase. And thirdly, footnote 17 makes reference to Rule 92, which is where the prosecutor decides not to open investigations. Here again, victims can make a representation. Now, these rights are written in the statute. This is not something new. So for that matter, I wouldn't want to believe that the chamber wanted to open a completely new chapter of engagement. But again, that is just me looking at paragraph 10 as it stands. I think that others will be in a position to give their own interpretational spin to it, but that's how I see it. And apart from that, there is a certain amount of engagement between the court and actors in the field, if you want to call it like that, already potentially during the preliminary examination stage. That is simple information exchange. And that is something that we are doing, have been doing, will be doing. And this is, again, not something where I think we have to be, I'd say, frightened that we're overcharging the system, because this is something that I think we can handle as a court with the resources that we have. Once I'm talking, just one, very short, 10 seconds. I heard again also the issue of how to responsibilize states. You know, how states could become an actor in terms of reparations or in terms of any assistance going to victims, which is not court-ordered reparations from the convict or the trust fund. Just one reality check here. We're dealing with a couple of countries, the majority of which will not be in a position to have any functioning restitution programs for victims simply because their infrastructure doesn't provide for it. And I think that it is a beautiful discussion to have where and how states could be held responsible to also afford reparations to victims. But we also have to face the reality that in many cases that will fail simply because there are no funds in the respective states' vaults. So that I think is just something I wanted to throw in addition.
And 2 sentences, please, to Mr. Dickert's question regarding the common legal representative for victims.
My apologies, Richard. I'm so sorry. Actually, it's a very interesting research done by Human Rights Watch on the Ongwen trial. It's really excellent research, very well done. And the problem that was raised by Human Rights Watch is a very pertinent one. If you look at Rule 90, which is the pertinent rule for the question of the rights of victims to have counsel, Rule 90, paragraph 1 says that victims have a right to choose their own counsel. And then you have a couple of sort of limitations that follow. And obviously, more than the other courts, in terms of our legal framework, we are held to actually be true to that rule and ask victims what their wishes are. I don't want to say whether it was a direct reaction to the Human Rights Watch report, but surely it was a reflected approach taken by the Al-Hassan Chamber after Ongwen. The Al-Hassan Chamber made it clear that they wanted the registry to go step by step through the Rule 90 process. That means, in the first place, reach out to victims directly, ask them exactly what their wishes are, and really gorge into this. So we as the registry were very explicitly ordered and held to follow the Rule 90 process by the letter. And I think that this is definitely a positive development from that, say, sort of institutional point of view. And we're trying the best to make that happen in the field right now. Thank you.
Amanda, would you like to take over Patrick's question and also say a couple of sentences to the legal representative or counsel for victims?
Sure. I'll keep it quick. I fully agree with Patrick's comments. We work in very similar ways in our work and have overlapped. And so I think what he's brought up is very important, and absolutely the legitimacy of the court is so enmeshed and intertwined with how victims see the court and how victims can participate in the court. And I do agree that, and as I mentioned, that the process itself of participation is such an important one. And that process, we have to recognize that in a court, in a criminal court that has a very specific agenda and is linked to a very specific situation and a specific perpetrator, is going to be very limited. And so this kind of links back to your question, sir, which is that I think from the perspective of those working with victims, I think we need to look beyond just participation in the courtroom. And for me, I mean, maybe this is a bit radical, but what I would love to see is more of a truth-seeking type of process, something similar to a truth kind of commission. And I don't know if the court, like a parallel system with the court itself or with the engagement of the court or something can be established where victims that are affected have a space to come and talk and share what they've been through, which is not necessarily to testify to a specific legal issue in the courtroom, but to just engage in sharing their perspective on the situations and on the cases more broadly. And so there are creative ways that we can think about how we engage, and I think something like a truth-seeking commission or a truth-seeking process also gets to the broader societal issues that were brought up in terms of the whole and the community. So,
Fiona, do you have anything to add to the question of the common legal representative and also the connection between the individual and collective reparations.
Just to add maybe on the choice of legal representative or counsel, you know, I was very surprised to see the Ongwen decision. I do think that it's really important that victims, so far as possible, are represented by counsel of their choice. For me, this is part of the, if you like, the complementarity approach of the court. That it's really it's important that as many lawyers as possible, for example, in the country concerned, get involved in ICC proceedings. It's really, when you ask victims what they want, it's very often very important. They say it's very important for them to have a lawyer that speaks their language, that understands their context. So I think there are so many reasons why, yes, I think where there's an option, then it's really important that the chosen lawyer is appointed, with the proviso that the registry always has to play the function, the court has to play the function of protecting the victims from being exploited, which can happen by lawyers. Now, on the individual collective question, you know, and it's an interesting interplay. Victim participation in the Rome Statute framework is kind of presented as an individual thing. However, if you look at the practice on victims providing representations at a very early stage, for example, on whether the prosecutor should be authorized to open an investigation, then there have been a number of examples where, because partly I think this came about because there just wasn't time to allow individual victims to put their views, to have victims put their views collectively. So to have some community representative, for example, or somebody else who could really represent the voices of a collective of victims. But that hasn't really, with one or two exceptions, come into the participation framework at the trial. But of course, when it comes to reparation, it can be individual or collective. One of the things that really struck me in dealing with reparations at the court is the very powerful sense from many victims of how important it is for them to have individual reparations and not only collective.
Peter, there was one question left regarding the assistance mandate, or anything else you would have to really add.
Yeah, we're out of time already, I saw that. Thank you.
Exactly.
I'd like to say one thing about about state responsibility. We talked about that. Philip talked about that too. I think it's important to understand that state responsibility to take care of its own citizens, victimized citizens, exists outside of the Rome Statute already, and is not conditioned to any decision of the court. It's there already. And this is also a very important understanding of how the fund operates its assistance mandate. It does not seek to replace or displace the responsibility of the state to undertake reparative actions in relation to its own citizens. If you will, that's reparative complementarity. Not in the Rome Statute, but it exists in practice. What does it mean? Indeed, some states don't have the capabilities to have their own reparations programs, or perhaps even better still, to invest in their line ministries to provide services, long-term services needed by victims, mental health care, medical care that is needed. But some states do. Cote d'Ivoire does, have a reparations program. Kenya, technically still a situation country, has a reparations program. And so in Cote d'Ivoire, the fund is in discussions with the ministry responsible for the implementation of reparations programs to see, on their request, how we can improve their performance there, to do so. In this way, we are creating less space for ourselves to have to intervene and to create value that may not be created by the national reparations program. About individual and collective, I mean, you may have institutional victims already participating in victims. That can be a form of a collective, depends who the institution is. There has been a lot of debate about individual and collective reparations awards. Individual awards are fairly easy to understand, and to date they have been mostly understood to be a form of compensation. Collective awards, I mean, there's no legal definition of what is a collective reparations award. The court has developed jurisprudence in which you may see different forms of collective awards. Collected to a certain group of identified victims, or victims who would need to respond to certain parameters, such as the case in the Lubanka case, former child soldiers. Not all victims are known already, but it's known that the collective awards will only go to that group of victims and not to a community. That is the other form that you might see. Symbolic awards or community reparations is a form of collective awards. And the fact that there is no definition gives the court, I think, discretion and space to understand the harm first suffered by the victims at the individual and on the collective level. And this is what I believe has been done in the Al-Mahdi case, where the court had a very thoughtful approach of understanding harm suffered in different layers. At the individual layer, at the family layer, at the community layer, the community of Timbuktu, as a community suffering harm from the destruction of the protected buildings, but also at the layer of Mali, as a community, at the layer of the international community. And the awards for the two final categories were symbolic, but the fact that these were recognized to be victims or victimized by the crimes as a collective, I think, is another form of expression of how you may understand collective awards. And often they happen at the same time. So beneficiaries from individual awards may also benefit from collective awards. You saw that in Katanga. And there's a lot of interplay that you may see in designing the response to the harm suffered by victims. Very important role for the court. And of course, important role for the fund also to see how you can translate those concepts into a practice that is meaningful for victims, that is efficient, and that can be funded. There's more to say, but I'm going to stop here.
Yeah, we have to. And unfortunately, we can't accept more questions. So let me very briefly summarize our results here before you will get really your coffee. And I can see you already moving on your chairs. That's an advantage when you sit here on the bench, actually. So what we've learned today in this first panel of this morning, that the system of victims' participation and reparation is a learning process. It's still not, has not been finalized yet, and Phillips made such a comment, and Amanda said that victims' participation is really essential to the trials, and we have to be aware that victims are not a burden, and that we don't see them as a burden in order to have the danger of instrumentalizing victims and seeing them only as objects for delivering evidence. We heard about the different challenges, and Peter gave the recommendations that we should see and treat these challenges as opportunities. And Fiona said that victims' participation and reparation, the system needs more support actually from NGOs in the field, from states, that we are all finally responsible for improving this system. And let me end with our beginning. Oh, I don't have the. Now it's up to you. With the quote of victim 480, and just let us try to be aware that we have to distinguish between the legal concept of victims and between victims as human beings. Thank you very much. Big applause to my panel members.